and lacked careful analysis. Each reached, I think, an erroneous conclusion. Each ignored the plain words of the Constitution. In Ritchie versus DeStefano, which came to her three-judge panel for the Second Circuit, it was an appeal by 18 firefighters. The test that they took to pass for promotion had been thrown out by the city, not because it was an unfair test. Indeed, it was never found to be unfair, but because the city did not like the racial results. Her opinion violated the constitutional command, I believe, that no one should be denied the equal protection of the laws because of their race. Judge Sotomayor did not deal with this important constitutional issue in a thorough, open, and honest way. Without justification, in my view, and in violation of the rules of the Second Circuit, they initially dismissed the case by summary order without even adopting the lower court opinion, with no explanation whatsoever. The effect was to deal with it in a way that would not require the opinion to be published or even circulated among the other judges on the circuit. The circuit rule states that when summary orders are appropriate only where, quote, a decision is unanimous and each judge on the panel believes that no jurisprudential purpose would be served by an opinion, close quote. So it was only after another judge on the circuit requested that the case be reheard that the panel issued a per curiam opinion, and of the briefest nature, only a few sentences, that adopting the lower court opinion. So I didn't feel good about that. That was a big case, a huge case of great importance. If not, the Supreme Court wouldn't have taken it, and they were trying to dispose of it by summary order. Judge Sotomayor's treatment of critically important Second Amendment issues that have come before her are equally troubling. Again, I think she got the text of the Constitution wrong and did so in a cursory way that seemed designed to hide the significance of the case and her ruling. In Maloney, even after the watershed decision by the Supreme Court in Heller, she held that it was settled law, that the Second Amendment did not apply to the states, and that the right to keep and bear arms is not, quote, a fundamental right. When asked about the Maloney case at the hearing, she claimed to have relied on precedent, but the precedent on which she relied considered the Privileges and Immunities Clause of the 14th Amendment. And the Supreme Court has not really looked at that clause for over 100 years. Instead, it's looked at the Due Process Clause under the Bill of Rights. And the law has changed how we do incorporation since the 1800s. And I think for her to fail to acknowledge that and to fail to acknowledge the very clear suggestion in the Heller case in that famous footnote that this matter is now open for consideration. Again, it's not settled law. In fact, the Ninth Circuit, reviewing the Supreme Court decision in Heller, reached a different conclusion altogether, that the Second Amendment does apply to the states based on the Supreme Court opinion. And I think that was a big error. And would note that if her decision is not overruled by the Supreme Court, on which she aspires to sit, then any city and any state in America could completely deny the right provided in the Constitution to keep and bear arms. And they could deny the right of people in their cities and their states to keep and bear arms. And a third case handled in a similar cursory manner, and the Maloney case was, what, 2 pages, a page, maybe less than 2 pages, was the important property rights case. 3 years ago, the Supreme Court in Kelo decided, 3 years ago after the Supreme Court decided the Kelo case, Judge Sotomayor's court issued an opinion in which a private property owner found his property on which he planned to build a CVS pharmacy taken by condemnation by the city so that another private developer could build a Walgreens pharmacy on it. And the developer, who was pursuing a redevelopment supported by the city, told the landowner he could keep the land and build that CVS as long as he forked over $800,000 to him and half ownership of his business. So in another two-page opinion, short, without much discussion, she rejected those claims. And the Constitution says private property can only be taken for public use. And that was not followed in that case. So each of these three cases of importance deserved to be treated with great thoughtfulness and care. Yet in each instance, her decisions were unacceptably short, and their only consistency was that the result favored a liberal pro-government ideology against the individuals asserting their constitutional rights. And so, Mr. Chairman, I appreciate you, and I know people will disagree on this and can disagree honestly, but after all is said and done, my evaluation of the testimony at the hearing and the study of the cases I've mentioned, I've concluded that this nominee should not be confirmed and will cast a no vote.
Thank you, Senator.